Developments in the former president's New York civil fraud case. Trump requested a delay in paying the $355 million penalty, and now a judge has said no. CNN's Kara Scannell joins us now with the latest. What was the reasoning the judge gave?
So Trump had asked for this delay because of the magnitude, this $355 million judgment. And the judge said that he did not provide, as he put it.
But Judge Engoron just responded to Trump's lawyers by email. The email is short. Here it is in full. You have failed to explain, much less justify, any basis for a stay. I am confident that the appellate division will protect your appellate rights. That's it. That's his answer to Trump's request for 30 more days to figure out how to pay $464 million. Denied. The anchor is right that the metaphor is imperfect, but the situation is real. Trump was ordered last Friday to pay $354.88 million in dislodgement plus $98.6 million in prejudgment interest. Once the court clerk enters the judgment, which could happen as early as tomorrow morning, the 30-day clock starts. Trump has 30 days to post bond covering the full amount plus interest, and every single day the clock runs, he owes another $87.52 in interest.
That's right. So from whenever it is finalized, Trump will have 30 days to appeal and 30 days to post $355 million plus $100 million in interest. So a lot of money. He'll have to put that together either by posting the cash himself or getting a bond that can be backed by collateral, some of his properties. But he'll have, about 30 days, and that includes the weekends. So if you kind of can guesstimate if this judgment does become final soon.
His lawyers called posting the full bond impossible. Letitia James said if he doesn't pay, she will move to seize his assets. And Engoron, the judge who spent months watching Trump's lawyers make arguments he found unpersuasive, told them what he thought of their stay request in one sentence.
Lawyers with the New York Attorney General say Trump's request doesn't justify why he should be allowed to delay, and the ruling doesn't leave any room for further debate. Now Trump has less than 30 days to make that payment.
Let me explain exactly what's happening and why each step in this process matters. The civil fraud judgment specifically was handed down on February 16, 2024. That's not the final number Trump owes. It's the core amount of ill-gotten gains determined Trump obtained through years of fraud on his financial statements. Added to that is $98.6 million in prejudgment interest, the interest that accrued during the period from when the fraudulent conduct began through the end of the trial. The combined total is approximately $454 million for Trump personally. Add in the amounts owed by Eric Trump, Donald Trump Jr. That number then begins accruing post-judgment interest at New York's statutory rate of 9% annually. On the full $454 million Trump portion, 9% annually works out to approximately $40.88 million per year, or approximately $199 to $83 per day. According to the AG's office's calculation, the anchor's $87,000 figure was the calculation at the time of Trump's stay request before the full judgment was officially entered.
Does Trump actually have the cash to pay this?
Well, if you ask Donald if he has the cash or not, he'll tell you he's very liquid and he has more than enough cash. Well, the problem with that is, if that's true, why then was he looking to figure out how to bond $5.3 million that was owed to the E. Jean Carroll verdict, the first one?
This is the financial clock that Engoron declined to pause. Every day from February 23rd forward, Trump owes more. By August 2025, without any payment, the total would approach $500 million. The clock runs during the appeal. The interest doesn't stop while the courts consider the case. The 30-day stay Trump's lawyers requested was not asking for a payment reduction. It was asking for more time before the clock started, specifically to give them more time to arrange financing for the bond. New York civil law provides an automatic stay, a pause on any collection actions by James. If Trump posts a bond covering the full judgment amount, so the process is judgment entered, 30 days, bond posted, automatic stay, appeal proceeds. If Trump doesn't post the bond within 30 days, James can begin executing against his assets.
For now, Trump is required to post a bond for hundreds of millions of dollars in the coming weeks. Our executive editorial producer, John Sant.
Before the appellate court in New York. The first, the money, and then the control of the business. So let's start with the money. On the money, big loss for Donald Trump and the Trump family.
Engoron's dismissal of the stay request was both legally and emotionally satisfying to read in the context of everything that had happened in his courtroom over the previous 4 months. Trump had violated gag orders. He had given testimony Engoron found not credible. He had stormed out of the courtroom. His lawyers had made 10 unsuccessful trips to the appellate division during the trial, and now they were asking for more time to deal with the consequences of the judgment, arguing that their client, who claimed to have hundreds of millions in cash, needed 30 days to figure out the money. Engoron's response: "No, go to the appellate division. I'm confident they'll protect your rights." The appellate division would not reduce the bond requirement immediately. It would take the full bond crisis, the 30 shy companies refusing to write the bond, Trump's lawyers filing a motion saying the requirement was impossible, and the March 18 filing deadline approaching before the appellate division reduced the bond requirement from $464 million to $175 million on March 25, 2024. That $175 million bond was then posted by Knight Specialty Insurance backed by Don Hankey. Cash collateralized within hours of the appellate division's order. The crisis resolved at the last possible moment. But on February 22, 2024, when Engoron's email arrived, the crisis was at its beginning. Trump's lawyers were trying to buy time. Engoron wasn't giving it to them. And the clock, $87.52 a day and rising, was about to start. Let me give you more context on what Lisa Rubin brings to this segment, because she's one of the most specific and technically accurate legal analysts covering the Trump cases. She's a former litigator. She actually tried cases before becoming a legal journalist at MSNBC. She was the off-air legal analyst for Rachel Maddow and Alex Wagner before becoming the on-air correspondent. She was one of the reporters who caught the significance of Engoron's email first, posting on social media, "Judge Engoron has reached his limits. It appears that he has signed the judgment and that all that needs to happen now is for the clerk to enter it." That observation, "the judgment is signed, the clerk just needs to enter it, and then the clock starts," is precisely the kind of procedural detail that matters in this case and that Rubin tracks carefully. The distinction between a judge signing a judgment and the clerk entering it into the official record is a technical legal point, but it's consequential. The clock doesn't start until the clerk acts, not when the judge signs. Rubin understood this and communicated it accurately in real time. The Anchor's Restaurant is Closing metaphor is a good faith attempt to find an everyday analogy for a legally complex situation. The Anchor acknowledges it might not be the right metaphor. The situation doesn't perfectly fit the restaurant analogy because Trump isn't necessarily closing in any business sense yet. What's actually happening is more like you've been found liable for a debt. The court has determined the amount and the process of collecting it is about to begin. The collection process has specific steps and mechanisms that differ from most people's experience with debt, which is what makes it hard to analogize. Simply the specific mechanism, post-bond or face asset seizure, is the part that's most difficult to analogize. In personal finance, if you owe a debt and don't pay, eventually your wages can be garnished or your assets can be levied. In Trump's case, the equivalent is that James could file the judgment in multiple counties and begin the process of executing against specific real estate assets. She said publicly she would do this. The properties at risk include commercial real estate in Manhattan. 40 Wall Street was specifically mentioned in the case, and potentially other Trump Organization assets. Trump's lawyers' characterization of the bond as impossible is worth examining. They said that the combined amount, $464 million plus post-judgment interest plus the 120%, typically required by shitties, would approach $560 million or more. Finding a single entity willing to guarantee $560 million against Trump's assets in an environment where any transaction with Trump's businesses was prohibited under Engoron's order was genuinely difficult. The 30-plus shitty companies that eventually declined to write the bond confirm this. The market was not willing to bet $560 million on Trump's ability to win the appeal. What ultimately resolved the bond crisis? Don Hankey's Knight Specialty Insurance cash collateralized at the reduced $175 million amount set by the appellate division represents the specific combination of factors that got Trump through the crisis. A wealthy ally willing to put up his own cash as collateral at a reduced bond amount that the appellate division allowed. Without both of those things, the properties were in genuine jeopardy. Let me address what Letitia James said publicly about asset seizure, because it was one of the most striking statements by a state attorney general in recent memory.
Financial gain.
No matter how powerful you are, no matter how much money you think you may have,
No one is above the law.
She told ABC News directly, if he does not have funds to pay off the judgment, then we will seek judgment enforcement mechanisms in court, and we will ask the judge to seize his assets. This isn't a vague threat. It's a specific procedural description of what happens when a civil judgment isn't paid. The judgment creditor, James's office, files to enforce the judgment, which can include placing liens on real property, garnishing accounts, and ultimately executing on assets through forced sales. The properties most obviously at risk are the ones in New York, 40 Wall Street, Trump Tower, Trump golf courses, because New York courts have direct enforcement jurisdiction over them. James's public statement about seizure served multiple purposes. It was a legal warning that collection would proceed. It was a political statement. There simply cannot be different rules for different people. Positioning the enforcement as a rule of law matter rather than a partisan matter, and it was a pressure tactic. The more publicly Trump's potential asset seizure was discussed, the more motivated his team would be to find the bond rather than let the properties be touched. The response from Trump's side was predictable. This was weaponization, a witch hunt. The judgment was wrong and would be overturned. Trump claimed to have $400 million in cash on hand. His lawyers simultaneously argued the bond was impossible. Both things cannot be fully true. Either Trump has the cash and can post the bond, or he doesn't have the cash, and the impossible claim is accurate. The financial world, the 30 shy companies, appeared to believe the impossible claim more than the $400 million in cash claim. The interest calculation itself, $87,052 per day at the time of Trump's stay request, rising to approximately $112,000 per day once the full judgment was entered, is what gives the clock its urgency. In the first week alone, from February 23rd to March 1st, Trump's bill grew by approximately $784,000. In the month of March, before the bond was posted on March 25th, the bill grew by approximately $3.4 million. This is money accruing on top of the original penalty, the entire time the appeal process runs. Even if Trump wins on appeal, which he partially did in August 2025 when the appellate division vacated the $354 million penalty on Eighth Amendment grounds, the interests that accrued during the appeal period would need to be addressed. Engram's email, 2 sentences, dismissive, confident in the appellate division, is the judge at his most economical. After months of verbose rulings, detailed findings, gag order hearings, and not credible determinations, he said in 2 sentences what he thought of the stay request. It's one of the most efficiently worded judicial communications in the entire Trump legal saga, and its efficiency is itself a statement. I don't need to say more. You had your trial, you lost. The appellate division will handle whatever comes next. Here's the broader context for why the bond crisis matters beyond the specific Trump legal situation. The mechanism that's being invoked, posting a bond to stay a civil judgment while appealing, is available to every civil defendant. It's a fundamental aspect of the appellate process. You can't just wait out an appeal while the other side tries to collect from you. You need to provide some security that the judgment will be paid if you lose on appeal. The bond requirement is designed to protect the judgment creditor, in this case the people of New York, through James's office. For wealthy individuals and corporations, this mechanism works reasonably well in most cases. You have assets, you post a bond or put up the assets as collateral, and the appeal proceeds. For a defendant whose assets are primarily real estate that was found to be fraudulently valued, whose businesses are restricted by the court order, and whose claimed liquid assets may be less than represented, the mechanism can become genuinely burdensome. This is the Trump situation. The 30-plus shitty companies that declined to write the bond are doing ordinary risk assessment. A shitty company that writes a bond essentially promises to pay the judgment if the defendant doesn't. They're betting that either Trump wins on appeal or Trump has sufficient assets to cover the judgment. Given the uncertainty about Trump's actual liquid assets, given the restriction on business transactions in the court order, and given the size of the obligation, the shies declined. This is not a politically motivated decision by the shitty companies. It's a financial risk assessment. The resolution, the appellate division reducing increasing the bond to $175 million, Don Hankey cash collateralizing at that amount, represents the specific accommodation the system made for Trump's situation. It's not without precedent. Courts can reduce bond requirements when the full amount is genuinely impossible to post. But the reduction from $464 million to $175 million is significant. It's a 62% reduction in the security required. The appellate division essentially accepted that the full bond was genuinely impossible and found a number that was feasible. Whether the Eighth Amendment vicar of the $354 million penalty in August 2025, which the appellate division eventually granted, finding the penalty constitutionally excessive, will ultimately affect the bond, and the interest is a question being litigated at the Court of Appeals as of March 2026. James is appealing the vacatur. The interest clock ran during the entire period. The numbers will need to be sorted out when the Court of Appeals rules. On February 22, 2024, though, none of that had happened yet. All that existed was the judgment, the clock starting, Engoron's two-sentence email, and the looming question of whether Donald Trump, who claimed to be a billionaire, could actually come up with the money to secure his appeal. Let me also address the specific language of Engoron's email one more time, because it's deceptively simple in a way that rewards closer reading. You have failed to explain, much less justify, any basis for a stay. The two steps explain and justify are distinct. Explaining would be here are the facts and circumstances that we're relying on. Justifying would be, and here's why those facts and circumstances legally warrant the relief we're requesting. Engoron is saying Trump's lawyers didn't do either. They didn't explain what the basis was, and even if they had explained it, they didn't provide the legal justification for why that basis should produce a stay. Trump's lawyer's argument was essentially, this is a big judgment and our client needs time to process it. That's an explanation of the circumstances, but not a legal justification for why those circumstances warrant a stay that Engoron wasn't already required to grant. There's no general rule that big judgments automatically get stayed. The existence of an appeal right doesn't automatically carry a stay. You need to make a legal argument for why the specific circumstances justify pausing enforcement. Trump's lawyers didn't make that argument adequately in Engoron's view. The second sentence, I am confident that the appellate division will protect your appellate rights, is Engoron directing Trump's lawyers to the forum where they should be making this argument. The appellate division has the authority to stay the judgment pending appeal. Engoron is saying, my job is done. The appellate division is the right court for this, and they will take care of your rights. The confidence he expresses is not a prediction of how the appellate division will rule on the merits. He's confident they will process the application appropriately, not necessarily that they'll grant it. Trump's lawyers did exactly what Engoron directed. They went to the appellate division. The appellate division didn't immediately grant the stay. The process of litigating the bond amount dragged through March. The impossible filing came in late February. The appellate division finally acted on March 25th. The bond was posted the same day. The stay went into effect. The clock was effectively paused. But from February 22nd to March 25th, 31 days, the interest continued to accrue. Approximately $111,283 per day for 31 days is approximately $347 million in additional interest that accrued during the bond crisis itself. Interest that accrued because Trump couldn't find a shitty company willing to write the full bond. The financial cost of the delay wasn't just time. It was money added to the judgment that was supposed to represent the amount of ill-gotten gains Trump obtained over a decade of fraud. Engoron's email closed this chapter of his involvement in the case. His judgment was entered. His stay request was denied. The rest was for the appellate division. He was done. And in 2 sentences, he said so. One last observation about the anchor's opening framing. What happens when you can't pay the check and it's a big check and the restaurant is closing? Because the anchor's uncertainty about whether this is the right metaphor is itself revealing. Finding the right analogy for Trump's situation is genuinely difficult because there's no real precedent for it in American political or financial history. This is a former president, current presidential frontrunner, who has been found liable for a decade of civil fraud and ordered to pay an amount that may exceed his liquid assets. There isn't a good prior example to draw from. The restaurant check analogy captures something: the inevitability of the bill, the question of whether you can pay it, the closing of the establishment suggesting urgency. But it fails because restaurants don't seize your properties if you can't pay, and it fails because Trump isn't eating his last meal. He's appealing the judgment, which means the restaurant question is actually, can you post enough security to stay in the restaurant while the dispute over the size of the check is resolved? Better analogies: a contractor's lien on a house where the homeowner is disputing the bill, but the contractor can enforce the lien against the property while the dispute is litigated, or a judgment in a lawsuit where the losing party must post a superseded bond to stay the judgment during appeal, which is exactly what this is. The specific legal mechanism has a specific name and a specific purpose, and it works in a specific way that the restaurant analogy doesn't capture. But the anchor's instinct that there's something viscerally satisfying about asking can he pay is exactly right for the political and cultural moment. Here is a man who has built an identity on wealth, who has told the world for 40 years that he is extraordinarily rich, who has used that claimed wealth as the foundation of his entire public persona. And now a court is asking, show us the money, post the bond, prove the wealth is real. And the market, 30 shy companies evaluating his actual assets and actual liabilities, said, we're not sure it is. That's not a political statement. That's a financial evaluation, and it's the most credible possible assessment of the question the anchor is trying to get at with the restaurant check metaphor. What happens when you can't pay the check? The answer in this case turned out to be your ally from the car loan business puts up cash collateral for $175 million. The appellate division reduces your bond requirement by 62%, and you post the bond at the last possible moment. But for 31 days in February and March 2024, the answer was not obvious. And Angeran's 2-sentence email is the document that started those 31 days. Here's the final frame I want to leave you with on the meaning of February 22nd, 2024. On this day, the largest civil fraud judgment ever entered against a private American citizen became real in a specific sense. The clock started, the money was owed, and the mechanism for collecting it was activated. The abstract finding of fraud became a concrete financial obligation with a daily growing bill. Trump's response, as always, was to treat the legal situation as a political situation. He was calling it weaponization. He was at rallies calling judges nasty and coordinated. He was fundraising off the judgment. He was treating the $464 million not as evidence of fraud, but as evidence of persecution. But Engoron's email doesn't care about that framing. 2 sentences, no engagement with the political narrative, no acknowledgement of the rallies or the Truth Social posts or the claims of innocence, just you failed to justify your request. The appellate division will handle your rights. The judge who spent months in a courtroom with Donald Trump watching him stare down witnesses, violate gag orders, storm out, and give testimony he found not credible, responded to the post-judgment maneuvering with the rhetorical equivalent of a shrug. Not today. Next court. Lisa Rubin caught the significance immediately. Engoron had reached his limits. The judgment was signed. The clerk just needed to enter it. And then the clock, 80, 7,500 to 200 a day, and rising would start.